I'm Steve Wilkerson, and I'm with Jim Saunders, Executive Editor of the News Service of Florida. Jim, the Florida Supreme Court reopened, it seemed, the entire state redistricting process last week with a decision allowing lower courts to consider lawsuits regarding gerrymandering. What's up?
Well, you know, the legislature last year redrew all the boundaries for the political districts in the state, and which is a big process. And some voting rights groups think that they have violated the state constitution, that essentially they, have gerrymandered some Senate districts. So they've been trying to pursue a lawsuit, and last week the Supreme Court ruled that in fact they could go ahead, that lower courts could go ahead and hear arguments, testimony, and look at evidence to see whether that, gerrymandering did happen.
Didn't they already rule on this?
Well, the Supreme Court does a sort of a overall ruling, but they don't get into all the nitty-gritty details of the maps. So that's what the voting rights groups have wanted to pursue. The legislature went to the Supreme Court and said, we need to block this, that the Supreme Court's already reviewed it, doesn't need to go back through the lower courts. But the Supreme Court in a 5-2 ruling went against the legislature. So it has really reopened litigation that could go forward for a while on these maps.
I'm sure the legislature was not pleased.
No, the legislature, they have claimed that this is the most fair and open redistricting process, which traditionally, of course, has been a very political process. And so they'd hope that the Supreme Court would just end this litigation at this point.
You mentioned the split of 5-2. You've been covering the court now for some time. Is that kind of a split number that recurs kind of frequently?
It's been going on for a while, but it has become very apparent recently. There's been a series of cases that have wound up in a 5-2 split. And the two most conservative justices, Charles Kennedy and Ricky Polston, are in the minority in those cases. The redistricting case, there was also other cases regarding some cases against insurance companies. There's a medical malpractice case. So the 5-2 has become very apparent.
With the 5, let's say generally siding with the trial bar, on the side of the consumer versus businesses that
on those types of civil cases, the insurance cases involving insurance, medical malpractice, and so on, they have been ruling in favor of the plaintiffs' attorneys against essentially the insurance industry, for instance. Another case, it was a doctor and a medical group. But they've been ruling in favor of essentially the consumers in those cases.
We'll follow you on this subject as you report on it. In the light of the intense reactions to the Martin Zimmerman case, have you heard, I know it's fairly recent, of any impetus to change the stand your ground law in Florida?
Yeah, immediately over the weekend, Senate Democratic leader Chris Smith started calling for the legislature to review the stand your ground law and also self-defense laws, which in some ways are similar, or very similar in some cases. And he has already called for the legislature to reopen those issues and to look at them again. I personally wonder how much traction he's going to get. After the Martin shooting, there was a Stand Your Ground task force that the governor appointed. Senator Smith himself convened people to come together. But then it went nowhere. The legislature basically had no desire to examine those issues again, so it's really went nowhere over the past several months.
And in the end, the case really wasn't decided on the Stand Your Ground law, right?
It was not. It became a self-defense case as opposed to a stand your ground case. I think for a lot of laymen like myself, sometimes those lines kind of blur. And I think from a political standpoint, they've definitely blurred.
Thank you, Jim. For more news about Florida politics and government, visit the Advances section of our website.